only a small part of what school police officers are trained to do, but local experts say the preparation for the officers was adequate. This is SRN News.
WTBN Pinellas Park, WTWD Plant City, WLCC Brandon.
Faith Talk Tampa. Download the Faith Talk Tampa app or listen on TuneIn and Odyssey.
Evangelist Franklin Graham is defending himself in the United Kingdom. Here's Michael Harrington.
The popular evangelist is 3/4 of the way through a major tour of the UK, preaching the gospel in stadium events to thousands. But British politicians, LGBT activists, and some clergymen are bashing him for his biblical stance on human sexuality. Graham tells Premier Christian News, quote, "The reason they say I'm a preacher of hate is because I say that marriage is between a man and a woman. Gay marriage, well, that's a sin. That's what the Bible calls it." Michael Harrington, SRN News.
A Christian woman faces a blasphemy trial in Pakistan. International Christian Concern reports a woman was arrested 9 months ago for allegedly insulting Islam in a social media posting. Her trial is expected to begin soon, but such proceedings often take years to conclude. Pakistan has some of the most draconian blasphemy laws in the world, with capital punishment the potential sentence for those convicted. This is SRN News. About 2 weeks after North Korea acknowledged its first domestic COVID-19 outbreak, it says 3.3 million people have come down with fever, but only 69 have died.
If the deceased were all virus patients, it would suggest the coronavirus fatality rate of 0.002%, something no other country has achieved. But there are widespread doubts about the credibility of North Korean tallies.
Florida will require statewide recertification for condominiums.
DeSantis has signed the bill as a response to the Surfside building collapse that killed 98 people. The governor's signature came right after the House unanimously passed the bill during a special session originally called to address skyrocketing property insurance rates. Recertification will be required after 30 years or 25 years if the building is within 3 miles of the coast, and every 10 years thereafter.
This correspondent Jeremy House reporting. More on these stories at srnnews.com.
The following program is sponsored by the law offices of Patrick L. Smith. This is the Attorney Patrick Smith Show. Get ready with your legal questions and call Patrick now. 877-943-9673. Again, that's 877-943-9673. The law office is open. And now your host, Patrick Smith.
Oh, hi there, and welcome to another edition of the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith, and we'll be with you for the next hour to answer your legal questions. Happy Memorial Day weekend, and a very special happy Memorial Day weekend to all our members of the U.S. Armed Services, those current, past. We appreciate your service, and of course want to recognize and say a special prayer of acknowledgement for all those who paid the ultimate sacrifice in support of this great nation of ours. So let us not forget what the reason for Memorial Day is, and that extra day off that we get on Monday is to honor those who paid that ultimate sacrifice. So in a tribute to that, if you'd like to call in today with your legal questions, you're welcome to do so, but you're also welcome to call in to honor a loved one who served in our U.S. military. So today, kind of working double duty, so to speak. You can call in with your legal questions or to honor a loved one who served this great nation in our United States military, any of the branches of service. 877-943-9673, 877-943-9673. That's your live and local number to be part of our show. You can call in now, open studio lines, ask your legal question, or honor a member of the U.S. military. 877-943-9673, or you can email Patrick at attorneypatricksmith.com. Again, you can email your questions 24/7. We do answer each and every one. 877-943-9673 to be part of our studio line, or email us Patrick at attorneypatricksmith.com. The usual gang here, plus one new addition. Well, technically one new addition. We have Yana, the Belarusian producer, Brian, the call screener, and our new intern, Clayman. The intern is with us now in studio as well. So the gang is here. We're happy to help any way we can. You can call in now. I'm local Central Florida attorney Patrick Smith, and we do this show every Saturday, and that's to help you with your legal issues you face during the week. We volunteer our time to come in here and answer your questions and give you the very best legal advice that we can. So again, that number to be part of the show, 877-943-9673, or email me, patrick@attorneypatricksmith.com. And speaking of email questions, I feel like I've been a little neglectful over the past few weeks with the in-depth discussion we had on the purported leaked Supreme Court opinion. And then last week we had special guest attorney Matthew Kendall on discussing criminal law matters. So I want to pay a little more attention than usual to email questions. I actually want to kick off the show with some email questions. So let's go to Yana with our very first email question of the day. Yana, good morning.
Good morning. And my first email question is, how old do you need to be to legally work in Florida?
So this is a great question. So there's actually some special rules on this. The general rule is 14 is the age to work in Florida. There's some special exemptions there. If it's for a business or it's working as a page, like the state legislature, things like that. And anytime someone is working at 14, I believe the cap is 15 hours per week. So there's a pretty strict cap there. And then once they turn 16, if I'm not mistaken, there's rules about not working before, I think it's like 6:30 a.m. or after 11 p.m. if schools are in session. So you can work as young as 14 or younger than that with special exemptions. And if you're 14, 15, 16 in that range, just be aware of the particular limitations that are going to be applied to working at that age. So yes, you can work as young as 14 or even younger under one of those special exemptions, but it is definitely something to keep an eye on if you're under the age of 18. And general understanding, 18, you're a grown adult, sui juris, and you can operate as a normal adult would in the employment field. So 877-943-9673, 877-943-9673. We're here to answer your legal questions today. Again, I'm attorney Patrick Smith, and we are happy to help any way that we can. So you can give us a call now, 877-943-9673. Call us now with your legal question, or to honor your family member or friend who served in the U.S. military. You're welcome to do so, and we will be happy to help any way that we can. I want to give you a very special invitation. Tonight, I will actually be doing a public appearance over at Muggs in Clearwater as part of the Patriot Talk Show. We will be doing that at 8 p.m. And I believe there's a meet and greet just prior to that. So if you'd like to show up and meet us in person, we will be at the Muggs in Clearwater tonight at 8 p.m. And you get a chance to meet me in person, shake my hand, and I'd love to meet you and say hello and meet some listeners of the show. So you're welcome to come out tonight, and that's 8 p.m. at Muggs in Clearwater. So it's the Patriot Talk Show. We'll be doing a panel discussion with Anna Paulina Luna, DC Drano, and several other political figures and dignitaries will be in attendance as well. So again, a panel discussion followed by an audience Q&A. And I'm very proud to sponsor the event, and I look forward to attending it. And again, a special thank you to our friend Brendan Leslie for organizing the event and calling in last week to promote it. So we hope you can be part of the event tonight, and we would love to see you there. So if you have a legal question, give us a call now, 877-943-9673, 877-943-9673, or you can email us, patrick@attorneypatricksmith.com. All right, Yana, let's do another email question. Yana?
Okay, is my will from Michigan valid in Florida?
Is my will from Michigan valid in Florida? The general rule on this, and this is probably the most common question we get at the law office weekly. It's to do with out-of-state wills or out-of-state trust or out-of-state documents in general and their validity within the state of Florida. And the general rule is if they're valid in the state of origin, they're going to be valid here. That, however, can be a little deceiving. You should not confuse validity with optimal efficiency. So if you have out-of-state documents that are valid in Florida, they may not be the most efficient version for you and your family, and I'll demonstrate for you. So if you have a will from Michigan, as the email question said, the will probably says, I, a resident of, and it says the great state of Michigan. Now, if you've become a Florida resident and the state of Michigan happens to have income taxes or estate taxes or whatever state level taxes, you're potentially subjecting yourself to that because you declared yourself a resident of Michigan. Now, it's possible you can argue out of that, but why have to go through those steps? Why run that risk? Why not just update the will and say, I'm now a resident of the great state of Florida? That's not making an invalid will more valid. That's making a valid will more efficient. So I think that's where a lot of the well-intending neighbors who share unlicensed legal advice with each other, and they say things like your out-of-state will is no good in Florida, what they're trying to say is that a Florida will could be better. It's not that the out-of-state will is invalid. And then the other particularity with Florida is the fact that Florida has pretty particular rules regarding the self-proving status of a will. So before a will is admitted to probate, the judge, if it's not self-proving, may require additional proof under the statute, such as an oath of witness. So you may, if your will is not self-proving, have to locate one or more of those witnesses and have them summoned to the clerk of the court and execute an oath of witness to get the will admitted to the probate process. That can add a significant delay to the beginning of the probate process. So again, updating the document for the state of Florida, you could do it in a self-proving fashion and have the will much more readily admitted to probate without those additional steps. So a great email question, 877-943-9673. That's your live and local number. We have open phone lines and we're here to help any way that we can. 877-943-9673. We'll be happy to help you any way we can. You can call in now with your legal question and we will give you the very best answer we can live over the air. 877-943-9673 or email me, patrick@attorneypatricksmith.com. So we would like to invite you to call in and be part of our show, and we'll be happy to help you any way we can. Multiple office locations throughout the state to serve you. If you'd rather come into the office during the week, we'll be happy to give you a complimentary consultation at any of our office locations, Clearwater, where I was yesterday, the Sun City Center office, or any of our offices over in Lake County and Claremont or up in the Villages. That number to schedule your complimentary consultation, 877-754-6764. Again, that toll-free number to call the office and be part of, call in and come, I'm sorry, to call the office and schedule your complimentary consultation, 877-754-6764, 877-754-6764. Give the office a call Monday through Friday, 8 to 4:30 p.m., and any of the staff will be happy to get that complimentary consultation scheduled. Had a very interesting conversation with a client who listened to the show and heard our particular broadcast on the constitutional presentation regarding the Roe versus Wade and the constitutional right to privacy conversation we were having. And they posed a question that I said I would pose here on the show. And the question was, when we're talking about the right to privacy and whether or not there was a right to privacy, the question arose whether or not the right to health care should have been a constitutional right. And I also think that's an issue that's brewing in the country. I don't think it's a settled issue. And I think that it sort of leads to where we left off in our constitutional law discussion on the right to privacy. The fact that the beauty of our Constitution is that it's structured to allow for amendments. And the challenge for the American people is not to grow lazy in amending the Constitution when we see the need for it. So the question the client was posing, and I said I would discuss it on the air, was whether or not there was a constitutional right to health care in the Constitution of the United States. And it's a fantastic point. Maybe you have a thought on that. You're welcome to call in and express your opinion. And I think that that's evidence of the fact that this dialogue on amending the Constitution is growing. And I think the American people are slowly recognizing the need for monitoring and adjusting the Constitution as the founders intended, and utilizing the process as outlaid in the Constitution for amending. So maybe you have a thought on that. 877-943-9673. 877-943-9673. That's your live and local number to be part of our show, or email your question, patrick@attorneypatricksmith.com, patrick@attorneypatricksmith.com, or give us a call now. We're on the air. We'll be happy to help you any way we can. Open studio lines, 877-943-9673. All right, next, Yana, another email question, please, and thank you.
I want to give my grandchildren money to help them buy their first home. How much can I give them without paying taxes?
So this is a very common scenario we face at the office during the week, where clients will call in and say, hey, I want to gift children, especially this time of the year, when you see graduation season coming up on you and wedding season coming up on you, you see a lot of families gifting large sums of money. And or they're large to me, at least, sums of money. And so they often call in and say, hey, what are the rules on this? How do I structure it so that I can make sure that everything's optimized? The current present interest annual exclusion, $16,000 per person per year. So that's the amount, and that regenerates annually, and you can gift that without paying any tax consequences. But we do recommend anytime you do a gift, you consult with your tax professional on how to structure it or whether or not you should file a 709, which is the gift tax return. If you go beyond the 709 or beyond the 16,000, again, realize you can make a gift beyond that amount, but you may have to pay gift taxes, or you may also have to allocate unified credits. Those are credits available to you upon your death. You're going to allocate them to the gift now, so that the net effect is you don't have to pay the gift tax. Now, it's not that you don't owe the gift tax. People misstate that all the time. They say, file the 709, allocate the credit so you don't owe the tax. You still owe the tax. You're just allocating credits so that you don't have to pay the tax. And I also think it's critical that you consult with the tax professional about those tax filings and whether or not they're necessary, because there's no statute of limitations for tax returns that are never filed. So I think it's incredibly important, but a great gifting question and very topical and seasonal, considering the gift giving season we're getting into with graduations and wedding season coming up. So if you have a question, 877-943-9673, 877-943-9673, open phone lines will get you and your question right on the air. You can also email me, patrick@attorneypatricksmith.com. All right, let's go to our first caller of the day. Let's go to Steve in Clearwater. Steve, welcome to the Attorney Patrick Smith Show.
Yes, thank you, Mr. Smith.
Hey, Steve.
The question is, I'm a small landlord in New Jersey. I have a commercial tenant, hasn't paid rent in 4 months. It's just been ignoring me completely. I filed for eviction through the court system, but they're so backed up, they haven't sent anything so far as it's even on a docket or anything. In the lease, it has a specific paragraph that you can have self-help, meaning you can lock the person out after you give them notice, which I did. And I'm just wondering, I spoke with one attorney, says, well, it's iffy if you can do that or not. What are the parameters of doing that, since it's explicit in the lease that this is the condition which I can do that?
So are you currently represented by counsel in New Jersey?
I have a legal service, and that's what they had said. It could be, argumentative if you go to court, but it is in the lease itself.
And you said it is a New Jersey leasehold property, so there's no tether to the state of Florida other than the fact that you occupy the state of Florida. Is that correct?
Well, I'm just here visiting. I will be moving down here permanently very soon.
And does the particular lease say that the laws governing any disputes are governed by the laws of the state of Florida or governed by the laws of New Jersey?
No, it was in New Jersey, but it doesn't say anything. Well, I guess, it would have to be New Jersey because that's where it was drawn up originally.
Yeah, I would have to defer to whatever. I'm not a licensed New Jersey attorney, Steve, so I wish I could give you the New Jersey answer, and I can't. So I would say I defer to whatever your New Jersey attorney has said. Have you only gotten one opinion from a New Jersey attorney? Or have you sought out a second opinion on that?
Yeah, well, I've done a little research and, through Google and all, and it says you can do it. And as long as it's written in there. And, I guess it's everyone's interpretation of it. But that's why it's in the lease, in case a situation like this arises. And, he knows the court system's backed up, so he's kind of milking it.
You're talking about the tenant now when you say that.
The tenant, yes. And, like I said, I haven't had any notice when it's even going to be put on a dock. It could be another 4, 6, 7 months. And what do I do? Just let him stay there? And he's been open just about every day. So
this is you said he's been open. This is a commercial lease, I'm guessing, not a residential lease?
Yeah. Oh, yeah, commercial. Not residential.
When is the lease due to expire on its own terms?
Actually, the 1st of June, he had a 5-year with an option for 5 years. And ironically, he sent a message that he wanted to renew the lease when he was still in default of the not paying the prior rent. I thought that was kind of ballsy.
Well, hey, at least he sent you some kind of notice. That was good. I
Yeah.
think that I would make sure when you seek out a second opinion, if you decide to seek out a second opinion, or if you don't, when you talk to your existing counsel, I would make them aware of that fact that the lease expires as of this date in Florida. That could have some, and there's actually an email question we got. We're going to get to where this is going to kind of dovetail with it a little bit, Steve. So at the end of the day, make sure your attorney knows that that is going to happen, that the lease expires, because in Florida, that'll change some things. And it may change some things under New Jersey law. But as I stated, I'm not a New Jersey attorney. I would just recommend taking that to your New Jersey attorney and maybe seeking a good second opinion from another licensed New Jersey attorney. And that way, if those two answers are identical, you'll know that's the fact. If there's differences, then you can ask some questions to follow up and find out why there's those differences in their opinions.
Okay, I appreciate it. One last question. When the lease is about to renew, if it was going to be renewed, what is the procedure? Is he supposed to send me a written? It was just basically a text he had sent me, but nothing was signed off that we were going to renew anything. What is usually the procedure in Florida if someone's going to renew a lease?
So in Florida, typically the lease lays out the terms for renewal. It'll simply say, in order to effectuate a renewal, the tenant shall give notice to the landlord within 30 days of this date. And, it's usually written notice. And I don't know whether or not a text message would count as written notice, but it seems like it would. I mean, it's certainly written. If I was advising a client on this, I would say send it certified mail. That way you have a receipt that the notice was sent and received. I mean, text messages often, maybe not delivered or accidentally deleted. It could be a gray area. And I think that, maybe you follow up with a text, but I definitely think you create some sort of physical paper trail. At least in Florida, that's how I would recommend it.
I see. And also, if I chose, which I am choosing not to renew the lease, should I just contact the gentleman and say, this is you're in default and that's the reason it's not being renewed?
Well, if you have a New Jersey attorney, I would just recommend you utilize whatever services they have and say, I would like you guys to handle letting the tenant know that in addition to this eviction action, we're certainly not renewing the lease. And I defer to whatever your New Jersey counsel says, Steve.
Okay. No, I appreciate it. I thought there were some other areas that, like by the time I get to the court system. So, all right, Mr. Smith, I thank you very much for your help. And we'll see what happens and I'll let you know.
Steve, keep us posted, okay? Good luck with everything and do your best to have a great Memorial Day, okay?
Thank you.
All righty. This is the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. 877-943-9673. Give us a call now. We're live and local. Happy to help any way we can. Simple. Just like Steve made it look, you call in with a question. That's a great example. So sometimes people call in and the question is not Florida specific, but we can still kind of give you a general advice on how to proceed, getting a second opinion. So we're happy to help any way we can. 877-943-9673. 877-943-9673. Open phone lines, and you can always email your question directly to me, patrick@attorneypatricksmith.com. And again, I'm local Central Florida attorney Patrick Smith. I've been in practice for over 15 years. This September will actually mark my 16th year in practice and helped thousands of clients over the years with primarily estate planning, wills, trust, and things of that nature. Probates and trust administration are my primary practice areas, but I work with attorneys in their own practices who practice in fields of lots of different types. So if you need help in any way, we're happy to assist you with a recommendation, or if it's something we can assist you directly with, of course, we're happy to assist. To talk to us live this morning, 877-943-9673, or email me, patrick@attorneypatricksmith.com. All right. While the next call is getting queued up, we're going to go for the first time ever to Clayman, the intern. Clayman, welcome to the Attorney Patrick Smith Show.
Hi, thank you. Good morning.
For those of you not familiar with Clayman the kid, or Clayman the intern, we were talking off air. Clayman, have you done any radio prior to your experience on the Attorney Patrick Smith Show?
No.
So you're a claimant, or your claimant is a radio novice, and we were talking about his first on-air experience, and he goes, "How will I know that I'm supposed to say something?" And it was very honest, and it was very endearing. And I said, "Well, I will tell you when it's time for you to say something." So, Clayman the intern, please, your first ever email question whenever you're ready.
If I'm living in a home, can the owner just kick me out?
So this was the question I was talking about, Steve, if you're still listening. This kind of dovetails with your eviction question. If there is a written lease and there's a non-payment of rent, there's a 3-day notice that can be sent. And that can get the person kicked out for non-payment of rent. In addition to that, you can also set it up so that if it's a breach of the lease, so they're paying rent, but they're doing something illegal or breaking a term of the lease, there's a 7-day notice requirement you can give to evict them if there's no lease at all. So this was the point I was making, Steve, when I said, did the lease end? If the lease ends and there is no lease in place, there's a 30-day notice that you can give, and that will allow for the eviction of the person under those rules. So it's either going to be 3, 7, or 30 days, depending on the facts and circumstances surrounding that situation. And that's why when you're occupying a home that's not yours, it's best to protect yourself with a good written lease, so you know you have an expectation of when you might be asked to leave and not have to leave suddenly. All right, let's go to our next caller. Let's go to Joanne in Venice. Joanne, welcome to the Attorney Patrick Smith Show.
Well, good morning.
Hey, Joanne. How can we help you today?
Yes, I bought a condo in Venice, Florida in last August. I have somebody that wants to buy it at a pretty good offer. Is it true that because it's less than a year, I still will have to pay 50% if I make any capital gains, even though because it's less than a year?
Did you say 50, 50, or 15?
50%, half of what I make on the condo.
So if you're talking, is this a primary property that you live in? Is it your homestead property, or is this a?
Yes.
Okay. So
yes.
this, and are
yes.
you going to be using the proceeds to invest in a future homestead property?
Within a year, yes. I thought I would, but they're still saying because it's less than a year, I will still have to pay the government 50%.
The accountant that I have had on the show before, Dwayne Bischoff, if you call me during the week, Joanne, I'll be happy to put you in touch with Dwayne, and he'll be happy to give you the direct answer to that. But my hunch is because you're going to turn around and reinvest in another homestead, I don't think it's going to be quite the pinch that you're portraying it to be. I think because it's going to be reinvested, I think that's going to be the outcome determinative factor there. But again, because this is an income tax issue, I lean on accountants a lot for that. There's 4 major transfer taxes under our Internal Revenue Code, and one is income. The other 3 we're pretty comfortable with: the estate tax, the gift tax, and the generation skipping transfer tax. But when it comes to income tax, Dwayne's our guy, and I'd be happy to put you in touch with him, and he'll give you the best answer to that question. Okay?
Well, thank you very much for letting me ask you a question.
All right.
Thanks a lot.
Joanne, you're welcome. What station are you listening on?
The Bone.
The Bone. All right.
Yeah.
Joanne, we appreciate you listening. Thank you.
Thank you. Bye-bye now.
Bye-bye. All right, you're listening to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. 877-943-9673. That's your live and local number to be part of our show today. 877-943-9673. And you can email your question, patrick@attorneypatricksmith.com. All right, next it looks like we're going to, is it line 2 or line 3? 2. We're going to Cheryl in Sarasota. Cheryl, welcome to the Attorney Patrick Smith Show.
Good morning, sir. I have a quick question. I realize that financial institutions have a lot of authority, but I got a letter from one of them indicating that they were going to close a credit card account that I have because of inactivity, and I had less than 90 days. And if I did not purchase something and put it on this credit card, then the credit account would be closed. I called them and said, well, then you're going to ruin my credit scores, and you're going to, do all this. And I said, that's set up for a overdraft protection. So I was trying to, navigate, through that. And I realized I could call the Better Business Bureau right to them, but it just seems like I'm being pushed and shoved, if you understand.
Well, a couple of follow-up questions. Number one, how long has it been since you've used this card?
Well, I've had the card for 3 years, and it's been on overdraft protection for 3 years.
Okay. So how
It coincides with my checking account.
Okay, let me ask
that
you
I
this.
have with the same thing.
When was the last time you put a charge on the card?
I haven't.
So you've had it for
You
3
mean like
years,
purchase?
and you've
Like
never.
purchase something? No, the only thing I've done with that card is to have it set up for overdraft protection.
So you've acquired the credit card and never used it.
No. It was set up for overdraft protection. I don't want to charge a lot of stuff to different credit accounts. I want to keep it organized.
All right. You know all that fine line paperwork language you sign when you sign up for the credit card?
No, I really don't know.
All right. Well, go back and look at it. And my guess would be buried in there. And without seeing it, I can't verify for sure. But buried in there is probably some sort of language regarding inactivity. And their suspicion may be if this is, in fact, a real person. Because it's not typical for someone to take out a credit card and then literally never use it. So, and I think what they want to see is some sign of activity. And, sometimes people pass away, and that's the reason there's no activity. And I think they're just sort of policing it. So what's the resistance or the hesitancy with throwing your next tank of gas on there, or just something to show them that there's some sign of life?
Well, actually, I decided to get rather snotty about the whole thing and send them a check to put a deposit on the credit card. Instead of purchasing something, I'm putting money on the card. Because I know if I do it that way, they will have to issue me a refund if I do not use that money. I know I've done that before, and I know I'm being a little snotty about the whole thing, but I'm really quite irritated because it was set up for overdraft protection.
Hey, Cheryl,
it goes with my my checking account.
Cheryl, it sounds to me like you are the type of person that does not like owing anyone money. Is that correct?
No, I don't like. No, I don't. No,
yeah.
no.
And I don't need to know your age, but I can probably guess your generation, and that's a sign of your generation. The idea of owing someone anything, and it's something that my father drilled into me growing up as a boy, that I would, one day owe a 30-year mortgage. And that would be the extent of my debt, if at all possible. And anything beyond that was somehow something we should pay off immediately or as soon as possible, because there's just this desire not to be in debt. And I hear that in your voice, Cheryl. But at the end of the day, if you're going to have a credit card companies make money when you use it. So if you're not using it, that's my guess why they're threatening to shut it down. If you want to get me a copy of all the paperwork you signed at the time you took out the credit card, I'll be happy to review it with you and show you kind of where that language is, if it's in there, okay?
Well, thank you very much. I figure it's probably in some disclaimer someplace.
You got it. That's more than likely where it is. Yes, ma'am.
Okay. Well, you have yourself a fabulous weekend, and thanks for at least listening to me.
Oh, Cheryl, happy to help, and I will be happy to get you a better answer once you get us a copy of that paperwork. You have a great Memorial Day, okay?
You have a safe one. Bye.
Bye-bye. All right, you're listening to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith, 877-943-9673. That's our live and local studio line to call in and be part of our show, 877-943-9673, or email us patrick@attorneypatricksmith.com. All right, next we're going to Aaron in Tampa. Aaron, welcome to the Attorney Patrick Smith Show.
Thank you. It's good to be on your show.
Thanks for calling in, Aaron. How can we help?
Well, it's a family law question. I've been with the same girl for 3.5 years, but she's technically still married to another person who they've been going back and forth on getting divorced. And her. And I was curious what that means. Does that mean, because somebody told me that he's responsible and I'm not technically the father till I prove I'm the father or something like that under Florida.
You were breaking up, and I feel like it was the worst possible time to break up. I think it was the most critical part of that question. So do you mind repeating that, Aaron?
Yeah, sure, not at all. So I've been with the same girl for 3.5 years. I have 2 kids with her recently. Well, 1 kid, one's on the way still. And then to somebody else.
Yeah, Aaron, it's still breaking up, but I got a feeling it's something to do with the children. And you said she's still legally married to someone else, and you have 1 child by her and 1 on the way. Is that accurate?
That is correct. Can you hear me better now?
Yeah, that's a little better. And so so those are the facts. What's the question?
So the question is, when she goes to file for divorce, which is finally going to happen, the kids, so 2 kids, one of the ways is going to be mine, but under the law, does he have any right to those kids because I'm still married? She's still married to him even though she's had him with me? That's what I was confused about.
Well, on the one that's been born, are you on the birth certificate as the father?
Yes.
And that's the plan for the next one as well. You'll be down as on the birth certificate as the father?
Yes.
I don't think it's going to be any issue for her divorce from her former spouse or current spouse that's soon to be a former spouse, because they're not children of his. Now, if you want to speak to a family law attorney, I'll be happy to give you a recommendation to one, and I'll give out the office line here again before the end of the show. You can call me during the week, Aaron. I'll put you in touch with a good one who can help you there. And now all this is happening in Hillsborough County?
Yes.
Yes.
Pinellas County, sorry.
Pinellas County, that's fine. I work with some very good family law attorneys in Pinellas who will be happy to assist you with that and give you the peace of mind that you're looking for. But as far as this attorney sees it, no, I don't see your children being subject to their divorce. That doesn't make any sense.
Okay, good. That's what I thought. But again, I'm not an attorney. You are. I'm glad you do this show. And I like listening to you, man.
Well, Aaron, I appreciate you saying that. What station are you listening on?
102.5 The Bone.
All right. Well, we appreciate you listening, and have a great Memorial Day, okay?
Thank you. You too, sir. Bye-bye now.
Bye-bye. All right, you're listening to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. The number to be part of our show, 877-943-9673, 877-943-9673. Give our studio lines a call now. We'll get you right on the air with your legal question, 877-943-9673, or email me, patrick@attorneypatricksmith.com. Next, we're going to Corey. And Corey, we don't have a location for you. Where are you, Corey? Do you mind telling us where you are?
Central Florida.
Central Florida. All right, Corey in Central Florida. How can we help you today?
I got hurt at work. I ripped out my bicep muscle.
Ow.
They waited too long, and now the doctor says putting it back together is not a really good option.
So
I am still working on light duty, but they're saying I'm going to lose percentage of my arm. What can I do about that?
Well, okay. So you need to obviously talk to a workers' comp attorney, and I can give you a referral to one, possibly a personal injury attorney, depending on how the injury occurred. And I don't know that it's best that you go into sort of detail on that on the air. And don't say the name of your employer on the air, Corey, whatever you do. You said they waited too long. Don't be terribly specific when you say they waited too long. Was it something your employer did, or was it a physician who waited too long? In your perception of the facts, who was the they that waited too long?
I would say the physician.
Okay. So that may be an issue beyond workers' comp, and that may be an issue of medical malpractice. And I've got attorneys I work with who handle those areas as well. So it sounds like you need a consultation with each, one with a workers' comp attorney and one with a medical malpractice attorney, or potentially one attorney who does both of those fields. And I'll be happy to give you the recommendation. And like I told the prior caller, I'll give out the office line here before the end of the show, Corey. So just give me a call during the week and I'll put you in touch with those attorneys. Okay.
Okay. Thank you.
Right. Well, I hope you feel better. Okay. And do your best to have a great Memorial Day.
All righty. Thank you.
You're
Have a
welcome,
good day.
Corey. You too.
Bye.
All right, you're listening to the Attorney Patrick Smith Show, 877-943-9673, 877-943-9673. Want to give out that office line as promised. So to schedule your complimentary consultation during the week, we'll be happy to help you any way we can. Our primary practice area is estate planning, where we do the basic will for $75, the power of attorney for $95, and the living will for $50, and my trust package for $695. And that fee of $695 for my trust package, that has not changed since the day that I opened my practice, I'm proud to say. We've kept that fee there to try to make the estate planning process as affordable as possible for everyone out there. So our trust package, $695. And if you'd like to take advantage of those flat fees for estate planning, 877-754-6764. Give us a call during the week and schedule your complimentary estate planning consultation. Or if you'd like to book us for a public speaking engagement like the one we're doing tonight, 8 o'clock mugs for the Patriot Talk Show. Or if you would like to get a referral to another attorney, you can always call our office, 877-754-6764. All right, next we are going to Mary in Tampa. Mary, welcome to the Attorney Patrick Smith Show.
Oh, thank you very much.
How are you today, Mary?
I'm good, thank you.
All right. How can I help you?
Well, this concerns some rental property. I rented an apartment in a high-rise building in Tampa almost 6 years ago, and at the beginning, I signed the lease for 1 year. Well, there was all these speculations in there and all these rules. But after the first year, we didn't sign the lease anymore. And what I'm wondering is, are the rules that were in the first lease that I signed, are they still effective, or did it end when the year was up?
It's going to depend on what that original lease said. And if you have a copy, Mary, I'm happy to review it with you free of charge and just give you my thoughts on it. But the lease is going to say one of two things: that the lease renews automatically unless you terminate it, or if it doesn't, then you'll be treated as a holdover tenant, and now you're basically month to month. And anywhere that the lease is not filling in the gaps, Florida state law will fill in the gaps where the lease is not in effect any longer. So I can't give you the exact answer because I haven't seen your particular lease. Do you have the lease, Mary?
Well, I don't have it with me. No, I mean,
that's okay. I wasn't going to make you read it live on the air. If you can get a copy of it, and if you have it, just call me at the office. I'll give you the fax or email. You can get it to me. I'll take a look at it with you, and I'll let you know exactly where you are, Mary. Okay.
Okay. What is your office number?
The office number is 877-754. 6764. So 877-754-6764. You can give me a call at the office and I'll be happy to get that taken care of for you. Okay.
Okay. I'll certainly do that. And thank you for taking my call.
You're welcome, Mary. Have a great Memorial Day. Okay.
You too. You too.
All righty. Bye-bye. All right. You listen to the Attorney Patrick Smith Show, 877-943-9673, 877-943-9673. 73. Give us a call now. Open studio lines. We'll get you and your question right on the air. Next, we are going to Sarasota, and we're going to talk to Janet. Janet, welcome to the Attorney Patrick Smith Show.
Hi, thank you. I'm calling because I was listening to a couple callers ago, a gentleman with a paternity problem. So I was in the exact same situation. I gave birth to a child while I was legally married to someone else. And I was told at the hospital that the father was not allowed to put his name on the birth certificate. The only name that I could put on the birth certificate was either my husband's name or just my name.
Wow.
But that the father of the child was not allowed to put his name on the certificate, even though he was literally at the hospital while I gave birth, said, "That's my kid." My husband was like, "No, that's not my kid." But is there any type, if the case is that was incorrect, is there any kind of recourse for that action?
Well, I think you could bring a paternity suit and have a determination of paternity. I mean, it sounds like it may just be a difference from hospital to hospital, because if you remember, the prior caller said he had 2 children, one on the way and one that was already born, and that occurred while he was still married to the spouse was still married to her former spouse. And if you remember correctly, he said his name was down as the father on the birth certificate. So Maybe it was a difference in that particular hospital's regulations. It sounds like that might be the case, but the solution would be doing something to establish paternity.
So it's not a Florida state law then. So it would be a hospital law. I mean we have no issues. The divorce is final and everybody's happy now. But I was just wondering.
That would be a question for a family law attorney, and I'd be happy to put you in touch with one as far as if there's a Florida state law saying that. But at the end of the day, whether the law says that or not, the father, the biological father, can bring an action in order to establish his paternity.
Okay. All right. Well, maybe I will look into that then.
All right, Janet, give us a call at the office if you want our help. We're happy to do so.
All right. Thank you.
Have a great Memorial Day. Bye-bye. All righty. You're listening to Attorney Patrick Smith Show. I'm Attorney Patrick Smith, 877-943-9673, or email me, patrick@attorneypatricksmith.com. Now we're going to Palm Harbor, and we're going to talk to Dimitri. Dimitri, welcome to the Attorney Patrick Smith Show.
Yes, Mr. Patrick. Would you like me to repeat what I said, or yeah?
Yes, because when you said it to Brian, the call screener extraordinaire, not to me, so I haven't heard it. Go ahead, Dimitri.
Oh, okay. Last June, I got in a motorcycle accident here in Palm Harbor.
Oh, I'm sorry to hear that.
And the motorcycle was with $80 just for my helmet to avoid. I didn't have full coverage, whatever. But I have injuries and everything else. And when I went to the hospital, they asked me for insurance, and I say my case is on the attorney. It's an accident. So they wanted my retirement insurance. I'm 72 years old now. And I gave them the Humana. So Humana pay, and they send me the copay, whatever. And I send it to my attorney who's handling my accident. They got the settlement, which was $100,000 tops, before Christmas, December. And I haven't heard from them yet. They say they still try to work a deal with the bills. Does it sound normal, regular, or something is there that I should be worried about?
So anytime you're not getting the communication you want from your attorney, I just suggest sending them a certified letter saying, here's what I would like to know about my case, and I would like you to respond in writing within this many days. And that'll shift the burden on them to respond, and the certified mail will let them know you're tracking it, so it'll have an added degree of importance there. But in typical, as I understand it, and again, we've had attorney Jared Bailey on the show, who is a personal injury attorney, and as I understand it from working with Jared over the years, it is a process where the settlement comes in, and then there's a payment of medical bills, attorney's fees, things like that, and then you should receive something called a settlement statement, where you see what was collected, what's been paid, and then you sign off on what you're receiving. That's my general understanding. And if you're not happy with the communication you're getting from your attorney, just write them a letter, express that, and tell them what information you would like to be provided that's going to make you happy.
Well, they did. They give me some kind of information, but they put me on the hanging like we're still waiting answer from the insurance to settle with the insurance, pay my bills, and then let me know what is left for me. They haven't to that point. I get in touch with them. I don't know if they charge me any time that I call, but 3-4 times. They give me the same answer, like we haven't got answer from the insurance, from Humana.
Did you sign a written fee agreement with them, Dimitri?
Pardon me?
Did you sign a written fee agreement with the attorney?
Yes, 33%.
So you know how they're billing you, and if they're billing you contingency, then they're probably not charging per the phone calls. So I wouldn't worry about that, but check the fee agreement. But what I would say is send a follow-up piece of correspondence saying, I appreciate the update. Can you give me an ETA on when you do expect this all to be settled, and see if they'll provide you that information.
Okay, sounds real good. Thank
all
you,
right,
sir.
Dimitri, have a great Memorial Day, okay? Thank you for calling.
Thank you. You've been a help. Thank you very much. Thank you too, sir. Thank you.
All righty. You're listening to the Attorney Patrick Smith Show, 877-943-9673. You can give us a call now. Email patrick@attorneypatricksmith.com. All right, let's go to Land O'Lakes and let's talk to Frank. Frank, welcome to the Attorney Patrick Smith Show.
Hey, Patrick. How are you doing this morning?
Doing great. How can we help you?
Okay, we don't want to take a lot of your time. Real quick, I have to represent myself pro se in a small claims court case because my neighbor damaged my lawn. Actually, his contractor did. I was trying to work with the contractor earlier this week to come to a settlement agreement, right? And then my attorney, or I'm sorry, not my attorney, but my neighbor's attorney, because I listed both of them as defendants, both the neighbor and the contractor, because the neighbor did things like gave permission for a plumber to come onto my property and repair some of the work without my knowledge, actually gave permission for the work to happen to begin with to cause the damage. So there's all kinds of issues there. Anyway, this attorney sent me an email earlier this week that said confidential settlement notice, right?
Okay.
And
Hey, I want
before
to stop you right there. If it said confidential settlement notice, Frank, it's probably not in your best interest to go over this over the air. Okay.
Well,
So,
I'm not going to. I don't want to talk about the details of that.
all right.
My question is: this attorney then reached out to the other defendant and talked about that confidential notice. Is that okay?
I don't know. I'd have to see that and review the agreement that was proffered. So if you want to call my office, I've got about 30 seconds here. But what I'll do is I'll give out the office line with the time remaining. Frank, give me a copy of that and with the cloak of attorney-client
It's all
privilege.
over email.
Yep,
Thank
that's
you,
fine.
Patrick. I will. You got it.
All right,
I will
Frank.
do that.
All right, Frank.
Give me the. Let me have that number.
It's 877-754-6764.
Patrick Smith. Thank you
Yep.
so much, sir. I really appreciate your
Frank,
time.
you're more than welcome. What station are you listening on?
102.5 The Bone.
All right, Frank, we appreciate it. All righty, you're listening to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. Write this number down for next week's show, 877-943-9673. Reach me at the office during the week, 877-754-6764. Very special thank you to all of our members of the armed services. Thank you for your service to our great nation. Go Gators. Stay safe. God bless. Have a great Memorial Day.
The proceeding was sponsored by the Law